in that area. But today I think is a topic that a lot of our viewers are very interested in, and for a number of reasons, that's criminal sentencing. And we know that that's what you do and have been doing for, well, I guess coming up on a quarter of a century pretty soon, if we say it that way. A couple of years, we'll be at 25 years.
Yeah, that's right.
Okay.
That's right. I've sentenced a lot of people.
I know you have, Judge, and I know it's a very, very difficult job, and we certainly respect you for it. I guess one of the reasons I think our viewers are as interested in criminal sentencing as a topic, though, is we seem to live in this world of the media, and any criminal activity seems like it winds up on the local news. And there are actually some television presentations, Law and Order comes to mind, that raise a lot of questions, and sometimes I think people would appreciate knowing a little bit more than just the theatrics of it. So I think a good place to start is a crime. How does this get defined?
In Ohio, all crimes are statutory, John. That means that a legislative body, whether it be the General Assembly of the State of Ohio with regard to crimes that are acts that are made crimes by state statutes, or a municipal government or a village council when they pass an ordinance, all crimes are statutory, which means that a legislative body has enacted a law or an ordinance or a statute that makes certain activity a crime. So when I say all crimes are statutory, that means that somewhere when a person's charged with a crime, whether it's a felony or a misdemeanor, whether it's the most serious crime of murder or just a minor traffic ticket for jaywalking, somewhere there's a legislative act, there's a statute you can go to, an ordinance you can look at that makes that activity a crime. And not only does it make the activity a crime, but it also prescribes the punishment. So, for example, if you go to Chapter 4511, which is the chapter of the revised code that deals with traffic offenses, the last section of that chapter, 4511, last section is 4511.99, and that sets forth the penalties that a judge could impose for a violation of Chapter 4511, depending on the code section. So all crimes are statutory, and all punishments are statutory, which means that the ability of judges to enact a punishment or the ability of judges to sanction behavior is that given to them by either the General Assembly in terms of state statutes or a city council or a village council in terms of misdemeanors that are violations of city ordinance.
That's interesting. So a crime has its roots in a law.
Yeah, it has to have its roots in a law.
But
that's right.
The part that I guess would be a layperson would come to this question: are you pretty much held to giving somebody the punishment that is exactly written in that book? Is there any leeway? I mean, as a judge.
Well, the leeway is this: the body that passed the law, whether it be the General Assembly of the State of Ohio or whether it be a city ordinance, a city council, or a village council, they give you parameters in which you can put the punishment in. Okay, for example, let's say that a person was charged with a offense of domestic violence in my court, which is a 4th-degree felony. So the maximum prison sentence that I could give that person is 18 months. Well, I can't go then give a 2-year sentence. I can't say, you know what, your behavior is worse than any other behavior I've seen for domestic violence, so I'm going to give you a 2-year prison sentence. I can't do that. I mean, the most I can give is 18 months. But unless the General Assembly was to say, look, for this offense you must give this particular punishment, then I would have a lot of leeway whether to put the person on probation, which is to suspend the sentence under certain conditions, whether to put the person in a county jail, which is to put the person in the prison system. So I do have a lot of leeway in that situation. Now, a lot of times the General Assembly takes away discretion. And what I mean by that is, for example, there are certain drug offenses for which the General Assembly has said you have to impose a mandatory prison sentence. There's certain sex offenses for which the General Assembly has said you must impose a certain prison sentence. There's certain deaths, homicides, including murder, for which the General Assembly says you have to impose a prison sentence. And in those situations, no matter what I personally think or don't think, the General Assembly is prescribing the sentence I have to impose. But sometimes, even in those situations, they give you some leeway. For example, let's say I had a drug offense which carried a second-degree, say I had a second-degree felony drug offense that carried a mandatory sentence. The mandatory part I have to follow, but whether it's 2, 3, 4, 5, 6, 7, or 8 years, that would be up to myself. So, for example, if I said to the offender in that situation, you're going to do 2 years in prison, that's a mandatory 2, but I could say to another offender who had a worse record perhaps, or who was involved with more drugs, I could say, you're going to do a mandatory 3 or a mandatory 4. So even in those situations, there's leeway. But a lot of people wonder, or I think a lot of people sometimes think that judges, when they impose a sentence, have total discretion, and that is just not true. I mean, our discretion is set, the parameters of our discretion might be the way to put it, are set by the legislative enactment that makes the crime and describes the punishment.
Harkening back to another show that we had, actually, I think she works under your direction, and Judge Collier, her name is Veronica Perry.
Right, our Chief Probation
Officer. And she advised us, or talked on the show one day, and said that her staff does something called pre-sentence investigations, which ultimately wind up in your hands and Judge Collier.
Right.
Is this a way to find out more about the person's background?
Right. What a pre-sentence investigation does is that Mrs. Perry's office gives us about maybe a 10 to 15 page report, depending on the offender, which can also, for example, have attached to that psychological assessments. In addition to those, it can also have the victim's impact forms, what the victim says happened from their perspective.
I see.
Can also have a recommendation from the victim as to what they believe should happen to the defendant. These have things such as the defendant's, their version of what happened, the official version of what happened. They have the criminal history of the defendant. They have the impact on the victim, any economic loss the victim may have suffered, medical bills suffered by the victim, if any. And they also have, at the end of it, which the attorneys, there's part of the report the attorneys see, and there's part of the report the attorneys don't see. And the part that they don't see is what the probation office recommends I do with the person. But that's not binding on the court. I've had situations where the probation department might say, we feel that this person's not a good candidate for probation, but I might decide to put them on probation, or vice versa. They may feel a person's a good candidate for probation, but I decide not to put them on probation. So the PSIs are pretty important because one of the ironies of the criminal justice system is that the person who is sentencing the defendant, myself or Judge Collier up in Medina County Common Pleas, Judge McElvain here in Wadsworth, we actually have the least, if the person doesn't go to trial, if they change their plea after they're brought to court, they go from a plea of not guilty, which they initially made, to one of guilty or no